A federal appeals court is now considering whether a Maine law limiting donations to political action committees is constitutional.
Yeah, the court heard some arguments on question 1 yesterday. This law was approved by Maine voters back in 2024. It would limit contributions to PACs or super PACs that spend money on specifically advocating for one candidate or the defeat of another in elections. Last year, the measure was struck down by a U.S. district court for violating the First Amendment. So the state filed an appeal soon after. Yesterday, attorneys for the state argued that the majority of super PACs are still unfairly aligned with specific candidates, even if they are not communicating with them directly. Opponents, however, argued the way that PACs operate still does not compromise election integrity or in any way violate the law.
There is disclosure of donations to super PAC expenditures, so that's out there. And there is no ability to coordinate whatsoever.
In an interview following the oral arguments, one of the defendant's attorneys shared an example of why they believe unlimited donations could have an unfair influence.
The scenario that we're worried about is like the scenario that happened in New Jersey with Senator Menendez. Menendez was approached by a rich guy. The rich guy said, if you'll do me some favors, I will give a whole bunch of money to your super PAC. The super PAC was completely independent. It didn't do anything wrong.
Now, both sides say Supreme Court precedent supports their individual positions. The challengers arguing that the 2010 case, Citizens United versus FEC, protects unlimited donations to super PACs, while supporters of Maine's law say that that ruling was about independent spending and not contributions. They say states should be able to limit donations to prevent the appearance of corruption.